Hello viewers, today we are going to take up our next unit, the unit 4th. We shall be dealing in this chapter regarding shares, share capital, allotment of shares, members transfer and transmission. This is the first part of our chapter belonging to unit 4th of company law portion. Now let us first discuss the whole procedure of the allotment. Whenever a company wants to come up with a share issue, it has to file certain documents with the registrar of company, that is ROC. Along with the prospectus, the underwriting commission contract is also filed. Now what is an underwriting contract and what is the commission? The underwriting contract is an understanding which is reached by the underwriter and the company to underwrite the shares. An underwriter takes many risks of underwriting the shares. In case the public does not subscribe to the shares, then he agrees to take up the shares that he has underwritten. Now there should have been an express authorization in the articles which is required for the payment of underwriting commission. Underwriting commission can be paid only in respect of those shares or debentures which are offered to the public for subscription. So, underwriting commission is payable only on the shares which are available for the public for subscription. Shares which do not reach the public and are not issued publicly, then no underwriting commission shall be payable on them. There is a ceiling which has been put regarding the maximum underwriting commission that can be paid by the company. Now this ceiling is 5% for the shares, equity shares or preference shares, and it is 2.5% of the value of debentures which are to be issued in the market. Let us see this section 76. The rate of commission on shares is maximum 5% of the price at which the shares are to be issued. On the debentures, maximum it is 2.5% of the price at which the debentures are issued. However, the articles can prescribe a lower rate. This 5% and 2% respectively for the shares and debentures is the maximum that can be paid by the company. So, a lesser rate could be settled up by the articles. Now let us discuss what has to be disclosed regarding the underwriting commission in the prospectus. The first thing which needs to be disclosed is the rate or amount of underwriting commission. So whatever is being paid to the underwriter, it has to be disclosed on the face of the prospectus. Second is the number of shares or debentures for which the underwriting contract is made. It's not necessary that there could be only one underwriter for the whole of the public issue. There could be many underwriters. So, an explanation of the amount of shares that they agree to underwrite should be given in the prospectus. Then is the name and address of the underwriters or underwriter. So, as many underwriters are available for the underwriting contract, their details regarding names and addresses should be provided by the company. A copy of the underwriting contract shall be filed with the registrar along with the prospectus. So, underwriting contract, which is an agreement reached by the company regarding the payment of commission and the amount of shares to be underwritten, is also to be filed along with the prospectus. Now we have to also see that beyond and besides the underwriting commission, there could be a brokerage which is paid by company to the brokers. Brokers are the middlemen who help out the company to make available the shares to the public and provide a channel so that the public can subscribe to the shares and fill up application to get the public issue. Now, this brokerage can be paid only to a person who carries on the business as a broker, that is a person whose business includes procuring subscription for shares or debentures. Brokerage cannot be paid to a person who directly applies for shares. So, brokerage is paid to a broker. Broker, like we said, it is a person who is a middleman and acts like intermediary between the public and the company, and he makes available the application for the shares to be applied for, and this brokerage can be paid only for the shares which are available through him. If the public is subscribing to the shares on its own, then no brokerage shall be paid. Usually the applications carry a code number of the brokers and the underwriters. The brokerage is paid only on those shares or debentures for which subscription is produced, that is, which are subscribed through the brokers and not on the entire issue. So, there could be an agreement regarding the entire issue for the broking, but as many applications which are actually received by the company through that broker bearing the code number, they shall be sorted and brokerage shall be paid only on such application reaching through him bearing his specified code. Nothing extra would be paid, and a disclosure regarding the brokerage commission shall also appear in the prospectus. Now, other points regarding the same: no authorization in the articles is required for payment of brokerage. The maximum rate of brokerage is not prescribed under the Companies Act 1956. Now, this is to be known that though there is a provision under section 76 regarding the maximum underwriting commission that could be paid to the underwriters, which is 5% and 2.5% regarding shares and debentures, no such provision is there for the payment of brokerage. Hence, any amount could be paid to the brokers as a brokerage. Now, let us try to know the legal rules as to the allotment under the Contract Act. Then we shall also be discussing the legal rules regarding the Companies Act. Now, firstly, the Contract Act. The authority for allotment regarding the shares is the Board of Directors. The Board of Directors may also delegate such authority to such person as it deems fit. The time for the allotment must be made within a reasonable time. Now, this reasonable time is actually 30 days of the closure of the subscription list. After the subscription list is closed, then a 30 days period is provided within which the allotment has to be finalized. The allotment is unconditional. The allotment must be absolute and unconditional. It is to be again recalled over here that when a prospectus is issued by the company, it is merely an invitation to subscribe to the shares. When the public subscribes through the application made to the company, then it is an offer, and when the company accepts that offer, it is called as allotment. An allotment creates a binding contract between the company and the shareholders. Hence, when the allotment is made, it should be unconditional. Now, communication of allotment. The allotment is not complete until it is communicated to the applicant, that is, a letter of allotment is duly posted. However, receipt or non-receipt of letter of allotment by the applicant is immaterial. The law demands that a communication regarding the allotment should be made. So, a contract is not binding on the shareholder until unless such a communication has been made, and this can be known if the company has posted a letter of allotment at a valid address provided by the shareholder. Whether such letter is received or not received is immaterial. Whether he has read it or not is also immaterial. It should also be seen that there is no contravention of any other act. The allotment should not be in contravention of any other act, that is the rule or the laws of the land. Now let us try to know about the rules under the Companies Act. Under section 41, no valid allotment can be made unless the person agrees in writing to become a member. Now this contract which has been entered by the shareholder agreeing to subscribe to the shares and consequent allotment by the company, in such a case the contract has already come into existence. Now such a contract will only be valid if it is in writing, and when a shareholder applies through an application which has been published in the prospectus, it qualifies this condition, and hence also the condition of the Companies Act section 41. Now there should not be any refusal of listing by the stock exchange, that is compulsory listing of the shares under section 73. Whenever a public issue has been made, it should be seen that the shares of the company are compulsorily listed in the stock exchange and they have not been refused to be traded on the stock exchange. Now this shall be applicable where the shares are offered to the public. The requirement is that the company shall make an application to one or more recognized stock exchanges for the purpose of obtaining permission for the shares and debentures to be dealt or traded within such stock exchanges. So this permission for the listing of the shares is compulsory whenever a public issue by the company has been made. There shall be a time stipulation regarding which the permission to deal in stock exchange has to be obtained. Now if permission has not been given by any of the stock exchange within 10 weeks from the date of closure of subscription list, it shall be deemed that such a stock exchange has refused to deal with the shares of that company on its stock exchange. Now what shall be the effect of refusal? The allotment shall be considered as void and the company shall forthwith repay the entire amount which has been received by it. So on refusal by the stock exchange, whether in written or deemed refusal, that is when it has not replied to the application to deal on such shares, then it will be assumed that the permission has not been granted, and in such a situation the company's allotment shall become void. Void means ineffectual, that means a no contract comes into being, and in such a case the company has to repay all the money that it has gotten under the application from the shares. Now let us discuss if the application has been entertained by the stock exchange and permission has been granted. There shall be a return of excess money where the permission has been obtained. Now if the permission for listing of shares or debentures is obtained from all stock exchange and the application money received from any applicant exceeds the application money on shares allotted to him, then the company shall repay such excess money forthwith without interest. There could be an instant where the applicant sent off excess money, or a case where the shares are allotted on a pro rata basis. Actual amount of shares that have been applied are not allotted to him, rather than that less amount of shares are given. So there is an excess of money which is lying with the company. After the permission to deal with the stock exchange has been granted and the allotment is valid, then this excessive application money in either of the condition has to be returned back to the share applicant. Another important condition regarding the share allotment is the filing of the prospectus or the statement in lieu of prospectus to the registrar of company, that is ROC. Now prospectus is like an advertisement. It is an invitation to the offer which is issued to the general public to subscribe to the shares. Whenever a company is coming with a public issue, then it has to come out with a prospectus which is available at all the stock exchanges through the chain of dealers, stock brokers, etc. A prospectus could also be published in the newspaper. Now, when a company is not coming with a public issue and it is able to get the funds or the shares or debentures through its own circle of friends, relatives or known people, then it could also issue those shares through another document called the statement in lieu of prospectus, which has almost the same features as the prospectus. Now, this statement in lieu of prospectus has to be filed with the ROC, just like the manner in which the prospectus is to be filed. Now, let us try to know about the other provisions. Before making an allotment, the company shall be filing with the registrar a prospectus or a statement in lieu of prospectus. However, this requirement shall not apply to a private company and in case of subsequent allotment of shares. So, the private company gets a privilege of not publishing a prospectus and filing the same with the ROC. A private company can allot the shares just by an agreement with the members and allotting the shares to them. Now, let us try to know about the section 69(1) regarding the minimum subscription. The minimum subscription is the amount of the application money which is required by the company for its issue expenses for a part of the project which can be financed. Hence, it is very important to get at least that minimum subscription. Now, this minimum subscription has been fixed at 90% of the issue. So, firstly, the company should be able to calculate its project cost for which it wants to fund through the public issue, and then also calculate 90% of the minimum subscription it is expecting from the public. Now, where a company makes an offer to the public for subscription of shares, no allotment shall be made unless the following two conditions are satisfied. The amount that is stated in the prospectus as the minimum subscription is subscribed. Secondly, the sum payable on application in respect of minimum subscription is received in cash by the company. So, the company has to see that both these conditions regarding the minimum subscription and the amount which is payable on the application has been received in cash by the company. So, this gives the company quite a lot of liquidity. It can pay the expenses of the public issue, plus it can fund the project. But this minimum subscription money cannot be right away used by the company at that instant whenever it receives it. It shall be lying in a separate bank account which is called as the banker to the issue. With that bank account, it shall be maintaining that money, and in case the contract becomes voidable or void, then from this separate bank account the money can be refunded back to the applicants. So, there is a restriction on this minimum subscription money getting mixed with the general funds of the company lying with its ordinary bank account. The minimum subscription must be received within 120 days of the first issue of prospectus. Otherwise, all money received from the applicants shall be repaid without interest within the next 10 days. In case the company has failed to obtain the minimum subscription, then it shall be liable to return and refund the entire money received on application within the period of 120 days. It also gets extra 10 days to refund the money without interest, but after the expiry of 120 plus 10 days, interest shall be levied on such an amount. Now, the minimum subscription according to the second schedule is that if subscription is not received within 90 days of closure of the issue, money received from the applicant shall be refunded. But in the SEBI guidelines, the stipulation is different. The minimum subscription shall be 90% of the shares offered to the public for subscription. the minimum subscription must be received by the company where the issue is not underwritten as on the date of closure of the issue, or where the issue is underwritten within 60 days of the closure of the issue. There is a variation in the time stipulation. In the Companies Act it is 120 days and under the SEBI guidelines it is 60 days. If the minimum subscription is not so received, that is within the time limit specified above, the amount received shall be refunded within the next 8 days. So, under the SEBI guidelines, when there is a failure to obtain minimum subscription, then within the 60 days time period, then additional 8 days are provided. So, it is actually 60 plus 8 days within which the money has to be refunded. Like we discussed earlier, that the money on the application has to be transferred to a separate bank account. The banker to the issue will determine the bank account and the company shall be opening a bank account with it. Under this section 69(4) and section 73, the application money received by the company shall be kept in a separate bank account maintained with the scheduled bank. The money so received by the company shall not be withdrawn from the separate account until the entire amount payable on application for shares in respect of the minimum subscription is received by the company and allotment up to the minimum subscription is made by the company. So, this money lying in the separate bank account shall lie intact and it shall not be allowed to be mixed up with the funds of the company with the ordinary bank account. Now, if the money deposited in the separate bank account is withdrawn in contravention of the above provisions, the allotment shall be voidable at the option of the allottee of shares. Voidable means it can be avoided. So, there is an option to the shareholders that because of contravention of section 69(4) and 73, if the money has been withdrawn by the company, then he can avoid this contract and give up his shares. The application money payable on each share shall not be less than 5% of the nominal value of the share. If the share is say rupees 100, then 5% of this nominal value of share shall be rupees 5. So, 5 rupees should be coming by way of application from the public issue on each share. Allotment on opening of the subscription list. Where a prospectus has been issued, no allotment of any shares shall be made until the beginning of the 5th day after the prospectus is first issued, or the beginning of the 5th day after the public notice is given under section 62, or such later time as may be specified in the prospectus. So, the requirement is that if the company comes out with a prospectus, then after the prospectus has been issued, it shall give at least 5 days so that the applicants can read the prospectus, and then the subscription list shall be open to entertain the applicants. If a public notice has been given regarding the public issue, then again 5 days shall be given to read the public notice, understand it and then apply it. And there could be such later time which could be specified in the prospectus. Now, this is called as the date of opening of the subscription list, where all the applications are invited and they are entertained. Now, let us discuss section 61 regarding the restrictions on the variation in the prospectus. A company shall not vary the terms of any contract contained in the prospectus or statement in lieu of prospectus except with the approval of members in the general meeting. Now, this applies to all the contracts that could be entered by the company, including the contract of underwriting with brokers and any other contracts regarding the project, payment of dividend, security, etc. regarding the debentures. Now let us discuss the section 60, 69, 70 and 73 dealing with the irregular allotment. An allotment is said to be irregular if it has not complied with these sections. Firstly, let us know the reasons. Number 1 is minimum subscription not received under section 69. In such a case, the allotment is voidable. If the amount of application money is less than 5% of the nominal value of the shares under section 69, then also the allotment is voidable. Application money is not kept in a scheduled bank under section 69, then also the allotment is voidable. In all these three conditions, it is the right of the shareholder that if he wants to avoid the allotment, he can avoid under this section by giving back his shares to the company. If a copy of statement in lieu of prospectus is not filed with the registrar at least 3 days before the allotment under section 70, then also the allotment will be considered voidable. If a copy of prospectus is not delivered to the ROC under section 60, then the allotment is valid and the company and every officer in default is punishable with fine. That means in case the prospectus is not delivered to the ROC, the contract with the company and shareholder regarding the allotment of shares remains valid. Only the company will be liable for the payment of penalty, that is, it shall be punishable with a fine. And the last one, if any of the stock exchange has refused to list the shares of the company or has not granted permission within a period of 10 weeks from the closure of subscription list under section 73, then the allotment shall be void. The company shall be liable to return all the monies received on the application back to the applicants and the entire issue shall be considered void. With this, we are concluding our today's session. In our session today, we discussed about various provisions dealing with the underwriting commission, the contract of underwriting, brokerage, payment of brokerage, commission, etc. Also, we discussed regarding the allotment and its procedure, what is an irregular allotment and what are the consequences of the irregular allotment. I hope you enjoyed the session. Thank you.